The Idaho Supreme Court hears an appeal on a case that could be very significant for the future of ski resorts in Idaho. I'm your Idaho Backroads neighborhood reporter, Steve Dent, and Milus versus Sun Valley Corporation stems from a man dying on the slopes at Sun Valley in 2019 when he ran into a snow gun. According to court records, Stewart Milus was skiing down Lower River Run at Sun Valley when he skied across the back of another person's skis, then went headfirst into a snow gun. Stewart Milus unfortunately died from this incident.
I would describe that day as the day that I went to hell. I literally went to the pit of hell that day, and ever since I've been clawing my way back from that pit.
Stewart Milus' widow filed suit against Sun Valley. A district court ruled in favor of Sun Valley, but in December of 2023, the Idaho Supreme Court overturned that decision unanimously. Laura Milus blamed Sun Valley for putting snow guns in the middle of the run.
That's what they did wrong. They put monstrosities. They increased the risk, they created a danger. Of course there's inherent dangers when you take upon skiing, but what you don't expect is that a ski resort will create a danger by putting massive obstructions in the middle, right smack dab in the center of a beginner run.
Ski resorts have been protected from litigation through the Idaho Ski Area Liability Act, created back in 1979. Pretty much every state that offers skiing has something similar to protect resorts against lawsuits because skiing is a dangerous sport. The act states what resorts need to follow, but it also states that skiers and snowboarders have an individual responsibility through the code of conduct.
You should take that responsibility before you get on the chairlift, before you buy a ticket or a season pass. That doesn't mean that the ski areas aren't going to do whatever we can to make it as safe as we can. Absolutely we will. And this was a tragic case of a situation. But the problem is that Sun Valley, in my opinion, did everything they should do.
Ski resorts fear implications from this case could mean higher insurance premiums, which larger resorts could take on by passing those costs on to the guest. There's a fear that it could lead to Idaho ski areas becoming corporate, which hasn't happened like the rest of the ski industry, and it could bring dire consequences for small mom-and-pop resorts.
What we'll see is what we saw in Vermont in the 80s, what I saw in California in the early 80s, is small ski areas going out of business because they simply can't pay the additional insurance costs that it will take to keep the doors open.
The Idaho Supreme Court during the appeal hearing seemed to be weighing whether the yellow padding on the snow guns constitutes a visible and marked warning, if previous court cases did set a precedent for this case, and what the legislation in the Idaho Ski Area Liability Act really intends. The court will decide if this case will continue to a jury trial.
That's what this case is about, and that's what they're going to have to decide now, the Supreme Court, is where does the liability begin and end for ski operators.
Ski resorts had a large presence at the appeal hearing, including the owners of Lookout Pass and Silver Mountain, who flew down from up in the Panhandle. The Idaho Supreme Court will be on recess until early April, and we'll make sure to keep you updated on this case. I'm your Idaho Backroads neighborhood reporter, Steve Dent, for Idaho News 6.